I'm Kimberly Crenshaw. I'm a professor at law at Columbia and UCLA Law School, and also the executive director of the African American Policy Forum. It's been about a week since I heard about the Zimmerman verdict. I was surprised. I had a worry that it would come out this way. There's enough reason, given the history of the way that largely white juries have reacted to cases where race seemed to be very much a part of the different narratives that were being told. But yet, often hope springs eternal. Now that we've had more than a week to hear all the different perspectives being articulated, I'm less surprised about the verdict. There were many reasons that were given by what we saw as one of the jurors' perspectives, and they were rich with racial meaning, all at the same time that race was being denied as one of the factors to be considered. So, as academics who study race, we know that there are some tendencies that many people have when they think about race, particularly white people, when they think about African Americans. So there is evidence to suggest that there's an empathy gap. I think if one saw the interview with the juror, you saw that she was empathetic, but not to the dead 17-year-old, but to the assailant, George Zimmerman, with whom she identified deeply. Many people see in that evidence of precisely the kind of differential empathy that gets expressed intraracially as opposed to against people of a different race. I think there is plenty of evidence that the veracity, namely the truthfulness, that white Americans attribute to non-whites, African Americans in particular, has historically been a problem. I think we saw that in the way that the juror indicated that she thought that the star witness was just not truthful. There was no evidence to suggest why she thought that. She just thought she was not truthful. So as I have been hearing what the juror had to say, and then importantly what people had to say about what the juror had to say, the racial divide that we often try to tell ourselves is dissipating is as wide as ever, and particularly evident in flashpoints like the Trayvon Martin case. Just because a verdict is rendered doesn't end the inquiry as to whether or not any civil rights were violated. That seems to be what a lot of people just do not understand, particularly about the possibility of federal civil rights violations. But secondly, I think people seem to think that the verdict was absolutely required by the law, or that the verdict came about because of prosecutorial failures, and therefore there was no other way that the jury could come out. I think it's important for those of us who know a little bit about the law to demystify the law and make it clear that while it is true that there was a self-defense statute that seemed to have facilitated a particular argument, that the jury actually had to exercise some discretion as to whether they believed that argument or whether they believed Trayvon Martin. So there's no imperative that the case come out this way as dictated by law. This is what juries do. They exercise judgment. Some part of the criticism is they exercise that judgment in a way that suggests that there was racial bias, and that goes to how they credited or did not credit particular witnesses, what they thought was reasonable, what they thought was not. So some of the criticism goes there. It's also the case that there's a lot of criticism to be distributed to the prosecutors. On the other hand, prosecutors make poor cases, winnable cases, every day in America. So again, there was nothing absolutely determined about how the prosecution went about. And lastly, and most importantly, people seem to think that if it was by the book, then somehow going by the book means that race is not playing a role, or that the book does not itself embody racial discrimination. And much of what many critical race theorists do and want to do in this case is to show people how going by the book often includes racial discrimination. It actually includes racial injustice. In fact, had Zimmerman been a police officer, let's say, everything he did would have been perfectly constitutional, including following Trayvon because he was African American, engaging him with excessive force, if there was some fear that Trayvon Martin would respond in a particular way. So it's important for people to realize that the distinction between what's legal and what's vigilantism is not nearly as stark as many people think. We are happy to have the opportunity to partner with the Critical Race Studies program at UCLA, the UCLA Law School and DePaul Law School, along with Laura Flanders and Grit TV, to offer a webinar on standing our ground for Trayvon Martin. And in that webinar, we want to talk about some of these issues. Did the jury have to do it? No. Did the law make them do it? No. Is race a part of this case? Absolutely. Is racial profiling constitutional? Unfortunately, yes. Are there things that we can do? Lots of things we can do.